Great. Well, thanks everybody for being flexible and joining us at our first idea lab in this Zoom environment. We're making adjustments like everybody else and trying to get our program back established this year by doing a lot more of these Zooms. So again, if we have a little technical difficulties, please bear with us. The first subject I thought was really an interesting one, and it really deals with some of the new regulations that were passed back in November of last year and will affect many of our businesses moving forward starting January 1st. And to help us talk a little bit about what those are about and what we need to do to comply, I wanted to introduce our speaker today, Paula Unger from Employers Edge HR Consulting. Paula comes to us with 20 years of HR laws and regulations experience consulting, and is here to break down a good handful of some of the laws that we are all going to be faced with complying with next year. So Paula, I'll give that to you, and I think you wanted to share your screen, so we'll see if that works.
Okay, sorry, give me just a second. Okay, here we go. Okay, so the first thing that I know that everybody was kind of watching towards the end of the year was the federal act that the Trump administration passed, the Families First Coronavirus Response Act, is what mandated that employers give employees time off for instances related to COVID. So if they had to quarantine, if they had to receive medical care, if they had to care for their children because their schools or daycares were closed and they couldn't work, remotely or things like that. So we were kind of waiting towards the end of the year to see if this was going to continue on a federal level or not, and it didn't. So this expired December 31st. But Colorado specifically, and a couple of other states have implemented a different initiative that covers all of this same stuff, but it's at the state level rather than at the federal level. So the FFCRA, the federal one, is now expired. Excuse me. So the one that Colorado put into place is called the Colorado Healthy Families and Workplace Act, and they're actually rolling it out in 3 different phases. So phase 1 went into effect July of last year. And this basically was just kind of a supplement to the federal regulation. So the federal regulation required that all employers that had under 500 employees had to provide this paid leave. The Colorado specific one took that determining factor away and said that all employers have to provide that kind of leave to employees. So this just kind of expanded it for Colorado employees. And then phase 2 went into effect January 1st of this year. It applies to all employers that have 16 or more employees in the state of Colorado. And then phase 3 is going to go into effect next year, and that will be for all employers regardless of size. So what this HFWA requires is that employers provide paid sick and safe time leave for their employees. So employers are required to provide 48 hours or six days for full-time employees. If they're part-time employees, that number can be prorated. And there's a couple of different ways you can do that. You can either front load that leave all at the beginning of the year, or you can accrue it as employees work throughout the year. And if you're going to go the accrual method, you accrue 1 hour per 30 hours worked for part-time employees, or if you have not, exempt employees, excuse me, it's just kind of you go off the fact that they should be working 40 hours per week. And then depending on how you choose to provide this leave, if you front load it or if you accrue it, you have to have the hours available to the employees to use as soon as it's accrued. So if you say, we're just gonna do it all January 1st because it's easier than having to keep track of the hours and accrue it, then everybody gets access to it on January 1st, or again, when they accrue it based upon the schedule. Any unused leave at the end of this year does have a requirement that it is rolled over. You can roll over up to, you can cap it at 48 hours. So employees, if they don't use any of this paid leave time this year, 48 hours will roll over to use next year. This is not required to be paid out if an employee leaves. You can, if you choose to be more generous than what's required. But if it's not paid out and the employee comes back to work for you within 6 months, you have to reinstate whatever hours they already had accrued. So you really want to make sure that you're keeping good records of, what's been accrued, what's been used, and, who's used what, all of that good stuff. So this, the leave specific to this act can be used for employees' mental illness, injury, health condition, anything medically related that's going to prevent an employee from working. If they need time off to obtain a medical diagnosis to get treatment of whatever's going on, a health condition, that qualifies as well as anybody in their immediate family. So that would be blood relatives, children, dependents. If they are a guardian for somebody, that would include those people as well. And then also this safe time is something that's been included this year as well. And this is specifically for an employee or anybody in their family that needs time off because they've experienced some kind of domestic assault issue, domestic abuse issue, harassment, things like that. And so this can be time off for them to receive medical care, counseling, if they need time off to relocate, if they need to attend to legal services, meet with an attorney, whatever that looks like. So that falls under this same bank of paid leave as well. So in order to receive the paid time off, the employees, they should request the leave as far in advance as possible. We all know that sometimes just stuff comes up and it's not possible to give as much notice as you would like. But we just ask that employees try to give us as much notice as they can and how long that they anticipate being out. As an employer, you can write up a policy or a procedure that says, these are the steps that you need to take if you have to request leave under this law. But if something comes up and the employee does not follow that exact procedure or policy that you have written, you can't deny their leave because of that. So it's really, it's a good guideline to have and say, this is what we want everybody to do. But if they don't comply with those specific procedures, you still have to grant their leave. And it's different from with FMLA, you can get really detailed documentation as far as the health condition and that kind of thing. Employers can require reasonable documentation for this, which basically just says, I need something that shows that you were out for, an instance that is covered under this plan. But you cannot get detailed health information on the employee or the family. And if the employee does not want to provide any type of information for you, you can't push it. You can't push the issue. So you really you don't want to open up those lines of communication with the employee. If they request something to you over the phone or they come to you in person or whatnot, document for your own records what they said. But the documentation requirement is not going to be as strict as it is under the FMLA. And any documentation that you do get on, any of this stuff for your employees, you have to keep it separate from their normal HR file. It would be considered HIPAA information, private information. So you have to, really restrict who has access to that. Oh, come on. There we go. So there's also something written into this act that says, as an employer, you cannot retaliate against anybody who requests the leave or uses the leave. This is all in good faith. We really would think that if an employee is using this, that it's for a legitimate reason. You can't take any kind of disciplinary action against them or anything like that if they're requesting and using this paid leave. A lot of people already have paid leave policies or banks or whatnot in place. And if you already have a policy in place that is equal to or greater than this 48 hours that's required, that's okay. You don't have to add an additional 48 hours on top of that. Where it gets a little bit sticky is that you have to add in those requirements for, you have to be able to roll over those 48 hours if they would like to. The documentation requirements are a little bit different and things like that. So, if you have a current policy and want to just use that instead of adding on an additional leave bank, that's fine. You just might need to look at your policy and make sure that it includes all of the requirements. Also, where it gets a little bit tricky is I know some employers have just PTO banks, and so they don't split out sick time from vacation time. With that, it could be a little bit tricky in terms of accruing and documenting and making sure that that 48 hours is specifically earmarked for paid sick leave. I think for just kind of ease of administering it, a lot of employers have gone to separating out their paid and sick leave banks. That can be a lot of work. If you don't want to do that, you just have to really be meticulous about tracking when the hours are accrued, how many hours are accrued, and then what hours are used specifically to this paid sick and safe time with the requirements of what it involves.
And Paula, that is the requirement. So if someone has just a general PTO that includes both, this requirement to keep these separate starts at the beginning of next year?
No, January 1st of this year.
It did require it this year.
Mm-hmm.
Okay.
Yeah. And again, it's not required that you break them out or make an additional bank, but you just have to make sure that 48 hours of that PTO plan is specifically earmarked for paid sick and safe time. So it doesn't have to be in addition if your plan already allows that, but it does have to be, recorded specifically for that time.
Great. Thank you for the clarification.
Sure.
Paula, correct me if I'm wrong. Paula, this is a hot topic for us. We went through this with our attorneys last week, which is why this caught my attention. We had a few employees inquire about this right away. And my understanding, based on my extensive conversation with our attorneys, is that what we're talking about right now, which started this year, only applies for this year, only applies to companies larger than 16 employees or more.
Correct.
But starting next year, it applies to everybody.
Exactly. Yeah.
Okay. So we're good there. The other place where I thought I heard a conflict in what I understood, and maybe I'm getting ahead of myself if I
no, that's okay. Go ahead.
Just say so and I'll wait. There's another component to this, which is specific to coronavirus, which is required by everybody up to 80 hours. Are we going to get into that as well?
Yep, that'll be coming up right next. Yeah.
I'll sit tight then. Okay.
No
I just want to make sure that I was tracking correctly. I've got my notes from our meeting last week and the notes I'm taking from your presentation. So I'll sit tight and I'll hold any further questions for the end. Thank you very much.
Yeah, no problem. And I didn't give the disclaimer at the beginning of the presentation. I guess I should have. I am not an attorney, but I've had a lot of those same conversations, George, with a lot of different attorneys, as this is kind of, since last year, as we were anticipating, and then now as it's actually happening, because sometimes they have an idea of what things are going to look like, but then once you actually implement it, it might look a little bit different. So so I've been spending a lot of time with attorneys too. I don't, I
Sorry.
There.
Yeah, no, it came up and we thought we interpreted it accurately. And then we thought perhaps there was a discrepancy. So we made that call quickly.
Yeah.
Then I saw this invitation come through like 2 days later. It was very timely. I'm
Good.
sorry you're seeing two of me. My old computer does not have good sound, which is why I'm on two different devices.
Oh, gotcha. Okay.
But anyways, go ahead. Thank you for clarifying.
Yeah.
I'll keep listening.
Yeah, no problem.
And while we're on the topic right now, just to clarify a little bit further, when you say next year, it requires all businesses, regardless of number of employees, that also includes all categories such as nonprofit, for-profit.
Correct.
It's all the way across the board.
Correct.
Okay.
Yep. But
Thank
this is state of Colorado specific. So if you are an employer who has employees in another state, this doesn't necessarily apply, although I know that some other states do have similar things in place at the state level. I know New York is one. I don't know exactly. I think Oregon has one. But if you guys have employees in other states and you have questions about that, let me know and I can research the state specific stuff for you. Okay, so recommendations on what to take or what actions to take for you guys to make sure that you're in compliance. Establish a specific sick leave plan if you don't already have one, or modify your existing plan so that it meets the requirements. If you can, split your sick leave out from your PTO, or otherwise just make sure that you're really being diligent in your documentation. Educate your managers about the leave requirements. And I think specifically where it could get a little dicey is making sure that your managers are not requesting, specific information and specific documentation like, you've been able to do under other plans. Oops, sorry. And then there are required posters that you have to provide to all of your employees as well. With everybody kind of, well, not everybody, but with a lot of people in this kind of virtual world that we're in right now, a lot of people don't have like a break room to stick up their posters on that everybody's going to see. So you can actually send these out via email. You can put them on your employee intranet if you have one, just as long as employees have access to it. I put the links to the posters in the presentation, but I'll actually send them to David or Lindsay so that they can distribute them out. So that you don't have to buy posters, you can just print them from online. And then make sure that you retain retain records of hours worked, time accrued, all of that good stuff. Make sure you hang on to it for at least 2 years. And then the second part of this that George had talked about was the public health emergency leave. So this one is coronavirus specific, COVID specific. And this comes into play when a public health official or state official, government official issues a public health emergency, which happened last year due to COVID, and then Polis has extended that into 2021. The last I heard, there's no tentative end date on that yet. I mean, I think that we'll just have to see how this plays out, more into the year. But as of now, it is effective as of January 1st, 2021. And this requires employers to provide paid leave for all employees up to 80 hours so that they can use for purposes related to the COVID emergency specifically. Where it's a little bit gray, and George, I'd actually be interested to hear what your attorneys had to say about it, but from what I understand, this is a supplemental amount of paid leave provided, but it has to be effective January 1. So if you have accruals for your employees and they don't accrue, say they accrue every paycheck or every month or whatever, you have to provide 80 hours to use as of January 1st upfront so that they have it if they need it right now.
That was your understanding. That was my understanding. This is the one that kind of surprised us.
Yeah.
We were interpreting the, I guess it's the HFWA, which you just reviewed with us, which we thought didn't apply to us because after furloughing most of our staff a month and a half ago, we only have now 6 employees. Mm. And then we got escalated to the senior employment law attorney at our law firm here locally, and they specialize in restaurants and small businesses. And he said, no, actually, like the last couple of days of December, I was going on vacation with my family and I caught wind of this. It's actually this Corona specific, and I don't want to get my acronyms mixed up.
I know there's a lot of them.
This is the public health emergencies statute that we're talking about right now.
Yes.
That is effective immediately, applies to everybody. And to your question earlier about when it ends, what I understood from him, and he is literally like interpreting this as we speak too, so it's new to them as well. But he spent a lot of time trying to wrap their brains around it because they have a lot of folks like us inquiring. But he said it will end when the public emergency status is lifted 40 days after that.
Correct. Yeah,
So
that's my understanding. Yeah.
Whenever that's determined, that's to be determined. Whenever we hit whatever levels or consistencies or level of vaccination, whatever the different milestones are, when it's declared over, we all look forward to that day. Then it's 40 days after that, and that's to be determined.
Right. Right. Okay. Good. Yeah, like I said, I mean, this is, and like your attorney said, this is all stuff that happened, very last minute, the last couple of days of December, and
Right.
I think it caught a lot of people off guard. And this is kind of one of those things that we're just going to have to see how it plays out throughout the year to see, how long we're going to have to do this. But I think the important piece of this to keep in mind is that once the public health emergency is declared over, you do have that extra time at the end of it that people can still take this paid time and use it, so that if they're say the public health emergency is over, everybody's great, go back to open up your businesses and go back to work, but somebody still has a COVID related emergency after up to 40 days after that time, they can still use this. So that's just kind of one thing to keep in mind.
Paula, is COVID related emergency, is that defined, or is that something that everybody's still trying to define?
It's not defined. It is basically when our public health officials or Governor Polis or whoever tells us that we're in the middle of a public health emergency, that's what it's defined as. But
to take the 80 hours, to take the 80 hours, the 80 hours is just paid leave related to the
it is. Yep.
The
so
emergency?
Here, exactly.
And so that's that's the area that isn't defined. Is what does that mean?
Sorry, it is defined. Yeah. So on my next slide here. So these are the instances under which you can use, or employees can use those 80 hours. So if there's a closure of the employer's workplace, if it's a temporary closure, to care for a child, if your child's school is closed, their daycare is closed, you can't work and have them run around in the background or whatever. To seek medical care for the employee or somebody in their immediate family, if they need to quarantine or care for somebody who's quarantined, or if you've got a high-risk employee who can't work from home but just can't work, can't risk it, that qualifies as well. And my notes actually say 4 weeks after the public health emergency is over. That might not be the most updated information. I think, George, 40 days probably sounds right. But again, this is something that we'll monitor and we'll get more direction on as we get closer to that time.
You know what? Upon closer look at my notes, it's actually 4 weeks. I said 40 days earlier from memory, and I should know better. I'm looking at my notes. It's 4 weeks is what I had as well. So I misspoke. I apologize.
No, that's okay. This thing is morphing every day, so I wouldn't have been surprised if my information was old.
Nothing like spreading bad information, right?
Yeah.
Paula, can I ask a quick question?
Yeah.
So, let's say that a family member passed away, but they're out of state, and you want to travel, take some time off to travel to their memorial service. That would not be covered, correct?
I don't know. Now, I don't believe that would be covered under this specific allotment of hours. But what might be covered is if you have to go to a state that, it's a high risk state and it requires quarantine after you get back from travel. If you have to quarantine for 2 weeks, when you get back, that would fall under this allotment of hours.
Gotcha. Okay. Interesting. Thank you.
Mm-hmm. So the last component of this is the public health emergency whistleblower law. And this basically just says that, all employees need to have to be safe in knowing that if their employer is not complying with public health guidelines, or if they're, doing using practices that are unsafe, and the employee can voice a concern without retaliation, is basically what this says. And this applies to all employers of all sizes, and protects any employee that, you know, might have a concern about the public health emergency and how it's being treated within their organization. So in terms of these things, here's kind of the recommended actions. Again, the poster, I've got the link for it here, but I'll send those out to you, David and Lindsay. So for the public health emergency leave, it is a requirement that information on that is distributed to all of your employees. So, you know, we recommend that you create a separate policy for that and distribute it to your employees, update your employee handbook if needed, but make sure that you do communicate it to everybody and make sure that you post the required notice. And then on the whistleblower part of that, you know, we're really encouraging people to review and update your policies for reporting pretty much anything. I mean, that could, you know, a lot of people already have reporting procedures for, you know, reporting harassment or things like that. But we just want to make sure that this is included in those, or that it's created if you don't already have one. You want to provide employees with multiple reporting options. Maybe they don't feel comfortable asking their immediate supervisor because maybe that's the person who's, you know, skirting the rules. So you want to give them multiple opportunities of where they can report these. And you want to encourage employees to report any health or safety concerns that they have, let them know that they will be taken seriously, they will be investigated. And then again, you know, no retaliation for that. So, you know, that's something that it really just needs to be communicated to employees so that they feel safe in, you know, if they see something that's an unsafe practice or that's putting people at risk, that they feel safe voicing that. Okay, so on the paid leave stuff, any other questions on that before I move on to the next topic? Perfect. So the last one that I'll talk about, or one of the last ones, the Equal Pay for Equal Work Act. This one's going to be a little bit tricky. So this was actually passed in 2019, went into effect January 1, 2021. And this is, you know, it sounds like a terrible time to implement this because of everything else that's going on with COVID and all that. But again, it was passed previously and it's just being required now. So this is specific to the state of Colorado as well. And it's really just ensuring that employees are getting paid consistently and the same for performing substantially similar work as their colleagues. And really, you know, where this has been a big issue has been that the pay disparity between men and women. This has been something that's been talked about and has been a real thing for a very long time. And so the state of Colorado is taking these steps to try and address that. So, you know, this is going to actually require you guys to make public your pay information and your salary information when you post a job. So I'll go over that in a little bit more detail, but you know, I think the big thing that's going to come out of this is how comfortable would you be with the rest of the world knowing what you're paying your employees? And if that makes your blood pressure raise and your you know, your heart beat a little bit faster, then maybe you know, need to just kind of take a look at it and make sure that you don't have any inequities internally. So here's kind of the top overview of it. So this applies to any employer who has one or more employee in Colorado, whether that employer is based in Colorado or not, if they are recruiting out of Colorado. So if you're an out-of-state business, but you say, hey, I've got this remote position open, yeah, that person can work out of Colorado. That falls under this as well. So again, it prohibits pay differences for different sexes for substantially similar work. And that work is not defined by what the employee's job title is. It's by the work that they're actually doing on a day-to-day basis. And it's not just, you know, the sexes that we're looking for disparities in. It's any protected class. But when the state of Colorado wrote this, that's really what they had in mind. The other thing is it prohibits employers from asking for any kind of salary history from job applicants. And where that comes from is, just because somebody was underpaid at their last job doesn't mean that as an employer you get to use that to bring them in and have them underpaid at your job. That just perpetuates the cycle, right? So you can't ask for any of that information anymore. And if they offer it up, you cannot use that in terms of, what you're going to offer to pay them. So just kind of, draw that line in the sand and just realize, regardless of what somebody was making before, this is what we would pay that person. It requires you to post all job openings. All job openings that you have to be posted internally, and list your salary ranges. And if you're not required to post every job externally, but if you do post it externally, you have to include those salary ranges. And you also have to include just kind of a basic rundown of your benefits. You don't have to go into specifics, but you can say, we offer medical, dental, vision, and life insurance. You don't have to get, real specific with it. And then, this also provides protection against any of your employees if they're sharing their salary information. You can't retaliate against that. You can't tell them that they can't do that. You can't discourage them from doing that. They have the right to talk about this stuff openly. And if you discipline them for doing so, or if you try to tell them they can't do so, they can actually file a lawsuit against you. So this is all just about, transparency. So where there are acceptable pay differences in the same job, you can base it on a seniority system. You can base it on a merit system. If somebody's overperforming or underperforming, that can affect their pay information. If you measure somebody's compensation based upon their production, that can be a difference as well. If they're in different locations, that's okay. We all know that some places are a lot more expensive to live and operate in than others. If they have more or less education, training, experience, that can account for some inequities, or I guess not inequities, but some differences in pay, or the amounts that somebody is required to travel. The thing is that if you do have differences in your internal equity, and it is because of one of these reasons, that's fine. You just really have to make sure that you can justify that based upon an employee's resume, based upon their performance, any of those things.
Can I ask a quick question,
Yeah.
Paula?
Yep.
This one also caught my attention, and I'll give you this last slide puts my mind at ease a little bit, but the scenario that was a little alarming to me, and I realize a lot of this is interpretation, but we have, let's say, a senior manager who puts in more hours. Ultimately, most of the responsibility falls on their shoulders, but they are more or less doing the same day-to-day work as the junior managers, for lack of a better. There is a pay discrepancy, and because that person tends to do the extra hours when they're needed and does the extra. In that case, as long as we can justify it, I mean, same it goes true for our not only front of house but our kitchen, right? We have a executive chef and a sous chef, and they both work their tails off. But the executive chef is the one who's here extra hours when the holiday promotions are,
Right.
in that seniority system, because we have kind of those ranks, if you will. Is that justifiable as long as they're close? I mean, it's not a massive discrepancy, but it's definitely a seniority system. And I saw this and I thought, oh my gosh, we got a lot of work to do there.
Yeah, I think the seniority system more applies to the length of time that somebody has been there. But where you guys might be okay is under the merit system. So if you guys do, any kind of employee reviews or performance reviews or, anything like that, and you can say, hey, this person is outperforming somebody that's junior to them. That's why they are a senior level. That's why they have the title and the pay increase. Even though they're doing pretty much the same job, they're kicking butt at it, and that's okay, as long as you can justify it. Make sure it's documented as to why that there's a difference in pay, and you'll be fine with that.
Okay.
Yeah,
experience, I suppose, too.
Yeah, exactly. Yeah, education,
Somebody has...
training, prior experience, any of that stuff. I know that this has got a lot of people panicking, but I think that it's not quite as bad as it sounds, because it does allow for differences like this, you know, when they're justifiable.
Okay, thank you.
Yeah, no problem. So in terms of the posting requirements, so you have to post all job openings, including internal openings, including promotion opportunities, which I think you know, there's a lot of confusion around and can get a little bit sticky. But you have to include the salary range, general description of the benefits, and if there's other compensation. So if there's a commission structure, if there's a bonus structure, anything like that, you don't have to be specific about it. It can literally just say, you know, there's a compensation structure and there's opportunity for bonuses. It doesn't have to be very specific, just needs to be included. So, and you can post it as a range. I mean, you can make it a pretty broad range, from the lowest that you would expect to bring somebody in, brand new, entry level, whatever, to the highest pay that you would reasonably expect to bring somebody in at. Now that's not stuck in stone. That doesn't mean that because that's what's posted, you have to stick with that. You can pay lower than the range, you can pay higher than the range, as long as the range that you posted was, you know, in good faith, reasonably what you thought that you would pay somebody coming in, and maybe circumstances changed between the time you posted it and brought the person in. That's fine. You just really have to make sure that you're, you know, doing it in good faith. If you get audited, you know, have to be able to explain why it's different, and you know, and don't make it a habit, I guess. If you do happen to get audited and the auditor comes in and sees that you're doing this on every single job that you post, it's gonna, you know, it's not gonna be good. What else I can say about that? Oh, the other thing to watch out for is some employers might think that they can kind of get around doing the work on this by just posting like, this is what our lowest paid employee in the company makes, and this is what our highest paid employee makes, so we're just going to put that range on everything. You can't do that. So you really have to keep it specific to the job that you're posting for. So if you're, you know, hiring for a janitor, you don't want to say that, you know, you could make $25,000 a year or you can make $90,000 a year, because that's not reasonable, right? So it has to be specific to the position that's posted.
Well, is there any requirement, or is there a perceived comparison to salary surveys within a certain profession
There can be.
by job title?
Yeah, I'll talk a little bit about that too.
Okay.
Yeah.
Sorry.
No, that's okay. That's okay. So the other thing with your posting requirements, is that you have to make a reasonable effort to notify all of your employees of the openings at the same time, which can be tricky if you've got people in multiple locations, if you've got people who don't have, you know, they're not on email, they're not on a computer system. So in order to do, I mean, it's just, you have to make the best reasonable effort to notify everybody at the same time. So if you are putting them on a company intranet somewhere where everybody has access to it, that's fine. If you want to send an email out to everybody, that's fine. If you want to post it in the break room, you know, with a paper copy, that's fine too, but you have to make sure that you're doing it in all of your locations at about the same time. Like, all employees have to be notified at about the same time. You don't necessarily have to, you know, send out an email or whatever if there are multiple promotions or internal openings coming up. You can put them all in the same notification and post them, say, every Friday or something like that. If it's something that is kind of always open for you, or if there's always opportunity for, you know, somebody to be promoted or whatnot, you know, just maybe put them all together and send it once a week. I was going to say one other thing about that and I lost my train of thought. I'll think about it. So the job descriptions and the wage history for all of your employees need to be kept for at least 2 years in case of an audit. And I'll get into in a minute a little bit more about what, you know, what we should do about your job descriptions and all of that good stuff. Okay, so these are just a couple of things to look out for. Like I said, depending on where your employees are located, it can make it a challenge to make sure that everybody's notified at the same time. If you have, you know, 1,000 job openings. I don't know how big everybody's business is, but you know, for companies that are huge and have a lot of job openings, this could really be an arduous process. It could be very time consuming. But you know, any job that is remote and has the possibility of working in Colorado, or not remote and you know could work in Colorado, if there's that possibility there, those all have to be posted under these same guidelines. The in-seat promotions, where somebody is moving up from, you know, a junior level to a senior level, those ones have to be posted as well. And the requirement in the act says that, you know, you're only required to notify people who could be, I guess, in line for that job. So if you're posting a senior level manager position, you don't have to notify all of your you know, entry level people because they wouldn't qualify anyways. However, it could be really, depending on the number of employees that you have, it could be quite the process to determine who would be eligible for this, who should we direct this to. And so I think a lot of employers are just posting them all across the board. But you can insert a caveat that says, you know, we're only going to accept applications if you meet these requirements. So you don't have to allow every single person in the company to apply. It just depends on how detailed you want to get with who you're notifying. The other thing that I foresee kind of being really tricky, and the attorneys that I talk to are a little bit concerned about this as well, is confidential job searches are going to be really hard. So if you've got somebody who's really underperforming in a position, but you don't want to let them go until you have a replacement for them, you're still going to have to post their job, and you're going to have to post the salary range on that job, and have, you know, the possibility that they're going to see that, or that somebody else is going to see it and let them know, and have to be prepared to answer those questions. Also, if your business is expanding, if you're moving into a new market geographically, if you want to, you know, start a new product line, previously a lot of places would, you know, kind of do the confidential job searches on the back end, so that once that happens, they've got people in place before they announce it to the public that that's what they're doing. You're not going to be able to do that anymore. And this is actually going to make it really difficult for headhunters. I don't know if you guys work with any paid recruiters or not, but a lot of them do the confidential job searches, and they're not going to be able to do that as easily anymore either. So there are some exceptions to the posting requirements. So this one's a little bit tricky, because some of the information that I've read says that even if somebody is underperforming and you want to replace them, but they don't know that they're being replaced, if it's a promotional opportunity for someone else in the company, you do not have to post it. However, if you're accepting external applications, you do have to post it and put the pay range on there. Does that make sense? Does it make sense in practice? Maybe not, but does that make sense how I explained it? So if the need for the confidentiality ends before you hire somebody else in there, either, you know, the employee that you're replacing learns about it and therefore it's not a secret anymore, or if they leave on their own fruition and it's not a secret anymore, then you must promptly post it, meet all the requirements internally and externally. If any employees are told of the opportunity, all employees who meet the required qualifications have to be notified. So you cannot cherry pick. And, you know, I see this a lot when somebody is like, okay, well, this person, you know, they're performing really well, they're doing great, we want them to move into the next managerial spot that opens up. That's where a lot of these pay discrepancies actually come into place, because people who maybe have an interest in it, but maybe the hiring team doesn't know they have an interest in it, are getting passed over because they don't know that the position's open, or they don't know you know, that the opportunity is even there. And so we really need to make sure that everybody is aware of all the opportunities that are arising, and that way people aren't like cherry picking their favorite employees and putting them into the top positions in the company as well. And that just goes, you know, that just lends itself to having a more diverse workforce and being able to have a succession plan and have promotional opportunities for people who you might not be at the top of mind. If you are doing something where you're replacing an underperforming employee, you can tell HR, you can tell your hiring team, anybody that needs to make a decision on that can be brought in the loop under strict confidentiality, because if one outside employee learns about that, then you need to disclose it to everybody. This is stuff I said before, you can, technically you only have to provide the notice to the employee who would be qualified for that promotion or for that, move in position. But again, that just depends on how much you want to specify who you're notifying, or if it's too much trouble and you just want to, put it out to everybody, which I think a lot of people will do. You cannot, like I said, you can't limit the notice to just people who you think are qualified or who you think might be interested, but you can put the caveat in there that says you have to have these certain qualifications in order to apply. You are not required to post anything if it's, somebody's in a trial period or a probationary period, and then, after they complete whatever that time frame is, then they're automatically promoted. As long as that trial period is no longer than 1 year, that's fine. If you are posting a position that's temporary, it's going to last for 6 months or less, that's not, that meets the exception. You don't have to post those. But if that turns into a full-time position, you do have to post those. And then multi-state employers, you're not required to disclose the pay information on your postings if there's no possibility that that job will be performed in Colorado. If you know that it's going to be an out-of-state job, that's fine. If there's even the remote possibility that somebody in Colorado could do that job, then you have to meet these requirements. So in terms of making sure that you're in compliance with this is what's recommended. Have a written compensation strategy and be consistent about it. Conduct a pay equity analysis, and that could, that consists of really looking at all of your positions, all of your job descriptions, making sure your job descriptions are up to date and they're valid with what people are actually doing on a day-to-day basis. I know the job descriptions are one of those things that, like, you throw one together when you need to hire somebody and then they don't get looked at again. But you really want to make sure that these are up to date, because if you get audited, you do need to supply backup as to why somebody is being paid the way that they are. Identify any job openings or promotional opportunities that are currently posted, and make sure that you throw the salary information on there and the benefits information on there. And make sure that all employees are notified. Again, they need to be notified at the same time. That could be on your company intranet, an email, bulletin board, whatever works for your situation. Make sure that all of your applications, whether you take paper applications, whether you have an online applicant tracking system, make sure that they remove the requirement for somebody's salary history. You can't even ask for it, just take it off. And then communicate these requires to your managers, anybody who might be on your interviewing team, let them know you can't ask for salary history, you can't, and then, make it a regular thing to do regular pay audits, if that's once a year, just to make sure that, nobody's coming in at, kind of wonky. In terms of the pay analysis, you'll really want to make sure that people who are in the same titles are doing substantially similar work. Just because they have different titles does not mean that you can pay them separately. It's based upon the job that they actually do. So George, in your situation, you might have a separate job description for a junior manager and for a senior manager, or just, a managerial job description, but with different levels. And, at that senior level, the requirements can state that, somebody who's in this position is going to be somebody who's performing above and beyond, taking on more responsibilities and that kind of thing. You really want to make sure that you're looking at any kind of protected class, gender, ethnicity, age, education, all of that kind of stuff, and making sure that there are no disparities that are like glaring, like, everybody who is female or who is of this race or whatever, we're not paying them as much. You don't want to, set yourself up for any kind of exposure there. Plus, it's just the right thing to do to not have those kind of discrepancies, right? So one of the ways, and David, to speak to your question, you do want to look at market data when you're doing this and see, for your industry, for your location, for the type of employees that you have, where does that fall within the market information? That doesn't mean that you have to pay at or above what market is paying, but what it does mean is that if you're going to use that information, you have to be consistent about it. So in order to set up your compensation strategy, you can say, we want to pay 80% of market average. That's totally fine. That's, if that's what you want to do, you just have to make sure that that's consistent across the board. So that goes along with, making sure that you have a written compensation strategy and, including that when you're evaluating job descriptions and the people who are in those positions. So, since this is new and it's, it's something that has just been put in place and there really hasn't been anything specific from the Department of Labor in terms of, when they're under what circumstances they're going to audit somebody or anything like that yet. I mean, obviously if an employee complains, that's going to be a big issue. But if you take the proactive steps to do a compensation analysis and really make sure that you're looking at your job descriptions and your pay and the reasoning behind any differences in pay. If you go through that exercise, fix any discrepancies that you might identify, if it comes down to it and you do get a complaint or you do get audited, the Department of Labor is going to take that into consideration and say, okay, you were proactive, you've looked at all this stuff, you've identified your discrepancies, you're working on fixing them or you have fixed them or whatnot. That's just going to give you a lot more protection in case, something like that comes up. Did that answer your question on that, David? Okay. The last thing, so this just passed in November, the Colorado Paid Family and Medical Leave. So that, like I said, this past November, but it doesn't go into effect until 2024. What this is actually going to be is, it's kind of an insurance program. The employee and the employer will split the premiums for it. And the employer can choose either you go with whatever state-run program they come up with, or you can have a private provider do this for you. But the premiums will start being paid in 2023, and then the paid leave coverage will become effective in 2024. And as of right now, what the intent is to give people paid time off, basically for what they would use FMLA for, but this is really geared towards smaller businesses that don't qualify or provide FMLA coverage. So we want to be able to give employees in those small business situations the opportunity to take paid time off if they need it due to health reasons, military, safe leave, any of that kind of stuff. Because it just passed and there's so many other things going on and it's not going to be effective for a couple of years, really that's all the information we have on it at this point. So that's kind of keep in mind that it's coming, but more to come as we learn more about that.
Is the qualification on that all businesses? Again?
Yes. Yeah.
That'll be all business regardless of number of employees?
I believe so, as of what I'm hearing right now. Yeah. Yep. Right. If you guys need any kind of help with getting into compliance with this stuff, this is just kind of a quick list of what I can do to help. I can do those pay equity analysis for you guys and update your job descriptions and get that market data for you if you would like me to. I can help you with policies. I can help you with training your managers and your people if you need to. If you just run into weird situations and you're like, I don't know what to do with this, or if you have questions once we get off of this call, I'm happy to answer anything I can for you. I'm happy to help however I can. This is my contact info, and I think David and Lindsay are going to send it out to everybody also. But I mean, feel free to reach out to me. I'm happy to answer any questions that might come up